This presentation is part of the discovery process. Just a little bit of background about discovery. Before 1956, California discovery was generally limited to depositions, inspections, and medical examinations. As a result of the Civil Discovery Act of 1957, the use of interrogatories and requests for admission were added. Unless there is a statutory exception, the Civil Discovery Act applies to every civil action and special proceeding of a civil nature. In this presentation, we're going to be looking at a part of discovery which involves a motion to compel. And we are going to be requesting for the interrogatories and for requested documents that were missing or not supplied. So to answer the question, what is a motion? When you become involved in a lawsuit, you may want the court to agree to something outside of the normal litigation process. For example, you or your opponent may want the court to drop the case, which would be a motion to dismiss, or to decide the winner without having to undergo a full trial, a motion for summary judgment. With a motion to compel discovery, you are moving or asking the court to order the responding party to provide information that had been requested of them, but they did not supply. Either they did not respond to the request, or the response that was provided was inadequate. So what are the required papers, or what does the motion to compel consist of? Well, it must consist of at least these following documents. The motion, which specifies what is being asked of the court, and it's sometimes referred to as a petition. The notice of motion gives written notice to the opposing party that the motion has been filed with the court, and it supplies the date and time for the hearing. Third, the points and authorities is a written statement of the legal reasons the court should grant the request made in the motion. And fourth, the separate statement, which is a document that makes it easier for the judge to see what discovery responses were made and what the insufficient answers to make it easier for him or her to determine whether there actually needs to be an order to compel further responses or not. The papers listed or the documents listed here can be filed as separate documents, or they can be combined into one or more documents. However, if they are combined, the documents must be listed separately in the caption at the beginning. This will be seen in an example which we will have in just a moment. For this next section, we'll just talk a little bit about how it is used. Motions are strategically important to litigation, and it is especially important to keep track of what motions are available to be used. The court will not file a motion for a party if they fail to do so themselves. Motions can be simple, such as a basic request or to compel discovery, or they can become highly technical, requiring an attorney to submit complex memoranda. The intent of using them is so that the case itself can ultimately be resolved in an effective manner. Different motions are used at different points in a trial, and if you take a look at this list, you will probably be able to recognize at what point many of these can be used. There are some things to be aware of when it comes to choosing whether or not to move to compel. Sometimes the options are a better choice. Because discovery is intended to be self-executing, virtually all motions authorized under California's discovery statutes require that counsel for both the moving and opposing parties make a good faith effort to informally resolve their dispute before seeking court intervention. counsel should consider other potentially more cost-effective ways of getting information. For example, if interrogatories were unsuccessful in getting the needed information, a deposition may provide that information more readily and less costly than a motion to compel further responses. There is an alternative. It's an informal meeting with the judge to resolve a discovery dispute. It's known as an informal discovery conference. It's fairly recent. Before January 1st, 2018, it was unclear whether a court could compel a litigant to set or attend an IDC as a prerequisite to the filing of a motion to compel. Effective May 1st, 2020, the civil panel began offering IDCs to resolve discovery disputes. Another important consideration is timing. The timing of a motion to compel depends largely on whether responses have been served. Here's a review of the timing in some common situations. This chart is just a sample of a few, and it shows you the time limits. Keep in mind that all discovery motions must be heard at least 15 days before the date initially set for trial. The trigger for a motion to compel discovery is that your side issued written discovery on the other party and they either gave no answer, an incomplete answer, or an evasive answer. If the responding party fails to serve any responses at all, there's no time limit on when the propounding party may file a motion to compel responses. When inadequate responses have been served, a motion to compel further responses may be filed and served within 45 days of service of the responses or any supplemental responses, or on or before any date to which the party agrees in writing. Failure to do so waives the party's ability to move for further responses. We'll now move on to look at the preparation of the first set of documents, which are the motion and the notice of motion. For this presentation, we are using the scenario of Sampson versus Emerald's Catering. The defendant, Emerald's Catering, never produced some of the documents that had been requested. They also didn't answer a request for interrogatories or for admission. Here we can see that these are three motions that are in one document, and they have been separated in the title. This is the second of 3 pages of the motion, which includes the highlighted wording, which it has been enlarged to the side to show you that these are the requests for the admissions, the special interrogatory, the production of documents, and all responsive documents. The highlighting will show you where these two items indicate the notice, the motion, and the request for sanction. And this is the final page with the attorney's signature, and it ends the presentation on the motion to compel discovery and notice to compel. The other documents will be presented by our group members. Thank you.